Thank you all for joining me for today's presentation covering today's recent regulatory updates, ongoing settled lawsuits, and we'll also discuss federal and state enforcement efforts targeting misclassification of employees as independent contractors. My name is Michael Visconti. I am the Director of Business Solutions and In-House Compliance Counsel for ICON Professional Services. Our company provides solutions for managing risks associated with proper classification and treatment of contractors and 1099 consultants. But as contract workers have emerged as a growing percentage of the national labor force and a strategic component for many companies when managing economic fluctuations, the answer to the ever-popular question facing many companies, which is better, the independent contractor or the employee, remains undecided. But for many companies, whether or not they know it, their managers are actually hiring independent contractors who would otherwise fail any number of tests set by state and federal regulatory agencies. What are the common reasons for this? Well, one, first and foremost, would probably be costs. Independent contractors can represent clear and calculable cost savings of 20 to 30% over full-time salaried employees. Misclassifying independent contractors gives many companies a clear and often insurmountable unfair competitive advantage over others in their industry. Second, often top talent will not agree to be a W-2 payrolled employee. Skilled workers who often describe themselves as consultants or outside researchers or freelancers will refuse to be chained to a desk as sort of a traditional W-2 salaried employee, preferring more of the freedom and flexibility of a 1099 contractual relationship. Finally, often it's simply ease of use. Companies and managers will often want to avoid jumping through any hoops set by human resources, procurement, and legal departments, allowing them thereby to hire at will without any delay, often without any oversight, avoiding company rules and regulations, and more often than not, those contractors show up as simply a nameless, faceless line item on a purchase order. When doing so, there's absolutely no way to know if they are compliant, and often the risk is masked, and the company is exposed to significant liability and possible legal action. But whatever the rationale, the incidents of misclassification are growing across the United States, and with it, the enforcement efforts by state and federal governments, as well as costly class action lawsuits by opportunistic plaintiff attorneys, of which I used to be one for the early years of my legal career here in California. So for the next 45 minutes, we'll discuss the unprecedented increase in government regulations, state laws, class actions, and mass action lawsuits over the past 3 years, and the significant fines, penalties, multi-million-dollar judgments levied on both knowing and unknowing companies who violated these laws and regulations. I'll go into highlighting the audits, investigations, and lawsuit triggers that face many companies, and what the effect would be if the current administration continues with its current trends and practices that they have very firmly established since 2009. We'll conclude with some best practices for avoiding these increased enforcement efforts, both by the government agencies and by private parties and attorneys. At the end, I'll reserve some time for questions and answers. Feel free to send those or wait until we open it up for questions and answers. Now, the White House has made absolutely no illusions in this time of tight fiscal policy and restricted agency spending that they are putting whatever eggs they have in one basket, and that is translating into direct and immediate monetary gains for federal and state governments. The IRS estimates that 15% of all employers have misclassified a total of 3.4 million employees as independent contractors. This has resulted in an annual revenue loss of about $3.4 billion and a loss of between $54 and $68 billion from underreporting of income by self-declared independent contractors. The results of audits bear this out, with 1 in 4 companies failing a misclassification audit, and almost half of all examined independent contractors being found to be misclassified. It therefore comes as no real surprise that in the last few years we have witnessed a massive wave of enforcement efforts and new laws specifically targeting the misclassified workers. Prior to 2010, the trend was being more formal information sharing agreements between agencies, including the IRS and Department of Labor. They were still uncertain about funding for the simple amount of money they could gain from this sort of heavy investment in misclassification. But the IRS decided to give independent contractors the ability to self-audit, aka sort of blow the whistle on their own companies, with a program that actually rewarded them with reduced exposure for any liabilities and unpaid back taxes that they may have had. Beginning in 2010, the federal government set aside millions for a formal Department of Labor misclassification initiative, and agencies followed with similar plans to locate vendors and violators and levy fines and collect back taxes. In 2011, we saw nearly a tenfold increase in the funds dedicated to finding and punishing those who flouted misclassification laws. The IRS extended sort of an olive branch to many employers who think they have misclassified large numbers of workers, but with that required heavy rules to govern them going forward, including requiring them to classify all similar workers in the future with the same classification, and requiring them to pay about 10% of their past due amounts. Unsurprisingly, plaintiff lawyers, always opportunistic, sensing blood in the water, followed the government's footsteps and began filing multi-million-dollar misclassification lawsuits against numerous U.S. employers, including dozens of Fortune 500 companies. Individual states added dozens of new laws. California alone in 2011 had 22 new employment laws passed. And this pattern in practice has continued pretty steadily up through 2012. So I'll begin with these ongoing agreements that gave the states and the federal government all this increased visibility and showed them not only the pervasiveness of worker misclassification, but how much money the federal government could actually get from enforcing these laws in earnest, and doing so with audits, misclassification task force, and lawsuits. So the collaboration between agencies began in earnest in 2010. In 2010, the DOL, the Department of Labor's Wage and Hour Division, collected nearly 400% more in back wages for minimum wage and overtime violations than it did so 2 years earlier in 2008. Also in 2010, the Congressional Research Service studies estimated that the proposed modification to IRS safe harbor rules would yield about $8.71 billion for fiscal years 2012 through 2021. And what really led them to all these fines and targeting all these employers was these formal memoranda of understanding and information sharing agreements between agencies like the IRS, the Department of Labor, and various state agencies and attorney general offices. To date, there are 13 memoranda of understanding between states and the Department of Labor. The last one's coming in February of this past year with Louisiana and Colorado in December, and there were another 10 states in September of last year alone. Furthermore, there are 37 information sharing agreements between the states, the IRS, and the Department of Labor. The effect is that these otherwise cash-strapped agencies can sort of leverage their personnel collectively. They can conduct more and sometimes overlapping audits. And often these audits have different standards and tests and rules for who is an independent contractor and who is not. And with these various tests and multiple agencies and multiple violations, you get numerous overlapping fines and penalties. So far, we've seen really no sign of end in this coordinating and joint investigations. And why would we? I mean, honestly, they're saving a lot of money doing this, and they're able to target the most egregious offenders and able to do so on a broad basis. Now, I'm going to focus on several key states. We're going to focus on states that have both taken the lead when it comes to misclassification initiatives and lawsuits, audits, and other investigations of the worst offenders, and states that are starting that process and following a very similar pattern to the states that have really led the way thus far. So these state-level task force, these commissions, and research teams are using agency audits along with unemployment insurance and workers' comp data all together to sort of document the scope of misclassification and determine which fines, penalties, and in cases of, say, Connecticut, stop work orders are necessary to penalize the employers who are misclassifying the largest percentage of their workers. So California had 29% of audited employers found to be misclassifying their workers, which accounted for $137 million in unpaid state income taxes. Between 2005 and 2007 in California, the State Employment Development Department recovered nearly $112 million in payroll tax assessments, $18 million in labor code citations, and more than $40 million in assessments on employment tax fraud cases. In Connecticut, 42% of audited employers were found to be in violation, and those accounted for $130 million in losses to state unemployment insurance funds alone and workers' comp funds, as well as state income taxes. In Illinois, the rate of misclassification by violating employers increased by 21% from 2001 to 2005, and in the following 6 years saw an increased number of laws and task forces across the state targeting specific industries. Massachusetts has largely led the way in new legislation and misclassification efforts, predominantly under the leadership of Attorney General Martha Coakley, and we will discuss that in some more depth in a few minutes. In New York, one of the big states that has really targeted sort of an industry-by-industry approach, where they have first they began with, I believe, the construction industry. Now they're moving into the transportation and trucking industry. In 2010, it reportedly identified 18,500 misclassified workers, and a total of 50,000 since it was started in September 2007. Their Department of Labor identified nearly 218 misclassified workers, all through unemployment insurance audits. I'm going to use Texas as an example of a state that is following in their footsteps. It has not nearly reached the level of California or Massachusetts, or in the case of Washington State. However, there's a lot of on-the-ground efforts that are pushing for similar changes to legislation, but as of yet, there has been very little movement, and that will discuss how that state is progressing as well. Finally, Washington State. Washington State had a staggering 62% of audited companies found to be misclassifying their workers. And what's more, the Washington State Supreme Court had a recent Supreme Court ruling that greatly extended the scope of what was previously thought of to be an employee. And we'll get into some more detail on that in a minute. Okay, beginning with California. We'll start with Assembly Bill 469, the Wage Theft Prevention Act. It requires employees to provide non-exempt employees at the time of hire with sort of a written notice of their rate of pay and other information ranging from hourly, shift, week, salary, or commission payment structures, and overtime rates if necessary and applicable. It further required significant disclosures ranging from allowances, addresses of various employer organizations and employer of record services, and details on workers' compensation policies and insurance providers. Again, remember that if an independent contractor is found to be misclassified, an employer can be liable for failing to follow the laws and regulations protecting employees, because in the eyes of the law, that independent contractor or perceived independent contractor should have been an employee and treated as such. Assembly Bill 887 clarified the extension to which the prohibition on discrimination in employment and housing used to punish discrimination on the basis of sex or gender to include a person's gender identity and gender expression. This greatly extended the sort of necessary provisions required by human resource departments when it came to issues of discrimination or perceived discrimination in the workplace. Assembly Bill 22, which covered credit report restrictions, put in very strict restrictions on when an employer can obtain credit reports for workers. It specified 6 categories, ranging from sworn peace officers to certain managerial positions to positions involving regular access to about $10,000 or more in cash. But of all these legislative actions and the 22 new labor laws California passed last year alone, Senate Bill 459, otherwise codified as Labor Code 226.8, which went into effect January 1st of this year, came out with the most costly penalties, beginning at $5,000 to $15,000 per incidence of willful misclassification of an employee as an independent contractor. Those fines actually raise to 10 to 25 if the company is found to have a pattern or practice of misclassification. Often that can be the case with many companies where they have large groups of employees or independent contractors similarly treated or similarly classified. And again, that can be $10,000 to $25,000 per violation. These are really unprecedented fines in California. Prior to this, violations of the labor code often incurred $50 or $100 fines, not $5,000 to $25,000 fines. And in addition, they added Labor Code Section 2753, which imposes joint and several liability on any consultants who knowingly advise an employer on an employee's misclassification as an independent contractor. Naturally, this excludes attorneys and those advising their direct employer, but that increase in liability is also unprecedented. What's more, these laws are now allowed to be enforced not only by an assortment of state agencies. As we previously discussed, those state agencies are all sharing information and sharing them nationally with the Department of Labor and the IRS. But now, it allows them to also be brought as class actions and potentially private attorney general act claims, which, not to get into too much detail, empower individuals to bring a lawsuit as sort of a stand-in for the state attorney and seek any penalties that the state of California itself could have sought for labor code violations. If that's not enough, it also included a scarlet letter provision where, should a company be found violating the SB 459 law, they have to post on their website in no uncertain terms and big bold letters that this company has been found to be violating the labor laws of California and has been misclassifying their workers. Often this will also be posted at a company's job site and major corporate headquarters as well. Now we'll discuss Connecticut, Illinois, and Massachusetts. Connecticut, we've seen a lot of movement there, especially between 2008 and 2011. The Department of Labor's Hartford, Connecticut office conducted 183 investigations of the construction industry employers alone. It recovered about $3.3 million in back pay and wages. The Connecticut Department of Labor presided over a threefold increase in civil penalties and had 159 crippling stop work orders during that period. A fun little statistic about that is that they had 17 stop work orders that they issued in just 1 week between about the end of September and beginning of October of last year. This proceeded to recover about $6 million in unpaid wages during the 2010 fiscal year alone. And how did they do this? Again, very informative, cooperative efforts using their memorandum of understanding and information sharing agreements with the DOL and the IRS. And remember, as mentioned before, misclassifying independent contractors, it gives employers a sort of insurmountable and unfair competitive advantage. In Connecticut and Rhode Island, industries like the construction industry are particularly prone to these kinds of violations because it allows contractors, when bidding on a job, to grossly undercut their competition. And there's been a lot of outcry from a lot of the people who are actually following the rules in this area that they are simply unable to compete with those who are violating the laws. What this has resulted in is sort of this multi-year enforcement effort by the Department of Labor in that state. They're targeting misclassification, noncompliance with wage and labor laws, and overtime pay laws. Now, this is a big increase as well. As we noted, in California, it used to be about $50 to $100. In Connecticut, it used to be about a $300 flat violation for a company doing these sorts of misclassifications. Now it's become up to $300 per day per violation. So if you look at that and you have 100 employees on a site, and even for 1 day, you're looking at $30,000. What's more, even with the state itself, and Connecticut is a great example of these varying laws and regulations. In the state alone, employers are required to comply with 2 starkly different laws governing the classification of workers, where the Department of Labor follows an ABC test, which we'll get into in more detail at the end of this presentation, while their Department of Revenue Services follows a more traditional common law test similar to what is governing the courts. In Illinois, the Employee Classification Act allows Illinois Department of Labor to level penalties of up to $1,500 for violations of the law and up to $2,500 for each repeat violation in the next 5-year period. Again, like Connecticut, these fines are per worker per day, and they can add up very, very quickly for employers. Illinois makes it a little more interesting where any interested party, again, this could be a disgruntled employee and a disgruntled independent contractor or what have you, can bring a civil action and get 10% of the amount recovered by the state. This is a very unambiguous sort of bounty hunter clause in the Employee Misclassification Act in Illinois. What's more, under this law, violators are subject to a doubling of penalties. They are subject to punitive damages, and both Class C misdemeanor charges for initial violations and Class 4 felony charges for repeat violators. Now, the Illinois Wage Theft Enforcement Act increases criminal penalties for violations of the Wage Payment and Collection Act and makes willful failure to pay wages due under the Act to a Class B misdemeanor and can charge amounts up to $5,000. It could be a Class A misdemeanor if its amounts over $5,000. Repeat offenses within 2 years of a prior criminal conviction are now a Class 4 felony under the new law. It also provides civil enforcement mechanisms. Employees can now pursue wage claims in court directly, either as an individual or in a costly multi-million-dollar class action. And what's more, they don't even have to file a complaint with the State Department of Labor. In many states, disgruntled employees, independent contractors, prior to filing these kinds of claims, are required to first notify the State Department of Labor, giving them first sort of bite at the apple. But in Illinois now, they are able to take it straight to court. Employees who do actually prevail in these wage claims may recover attorney's fees and costs as well as damages at a rate of 2% of the amount of any unpaid wages for each month that wages remain unpaid. And this is while the lawsuit is ongoing. Massachusetts, most of the efforts have come through Attorney General Martha Cooley. She announced a settlement with the 3 companies recently over allegations of wage and hour violations. The settlement included $2.8 million in penalties, fines, and restitution. This was the Tri-State Drywall Systems, National Water Main Clearing Company, and the Central Mass Disposal Unit. And they were all alleged by Attorney General Coakley to have violated Massachusetts' prevailing wage laws and misclassification laws. It resulted in sort of an underpayment of workers of approximately $1.7 million, and the companies were fined more than $1 million each for their violations. What's more interesting is under Massachusetts now, their statutes are sort of having a long arm effect where any misclassified employer, any independent contractor who had minimum contacts with the state can now be brought underneath their labor code and wage and hour violations. So again, if you're looking at a state like Massachusetts, which is sort of ahead of the curve when it comes to the degree of liability you could face, the amounts of fines and penalties, it's very scary to think that an employer or an independent contractor who had very minimal contact with the state could now be brought under their laws. Also very interesting, just today, this Monday, the Massachusetts Joint Enforcement Task Force for the Underground Economy and Employee Misclassification, they announced in their annual report that last year, 2011, it recovered $10.9 million in overdue taxes, resulting mainly from the misclassification of workers as independent contractors, included restitution and penalties and fines levied by Martha Coakley's office, and unpaid unemployment insurance taxes. In total, the amount recovered by her task force was up 68% from the $6.5 million they recovered in 2010. And this is almost a 7-fold increase from its first year, which was only 2009, just 2 years ago, when they recovered $1.4 million. So clearly there's no sign of slowing down, and Attorney General Coakley and her task force continues to make huge gains and get a lot of money for Massachusetts back from employers who've misclassified their employees. We'll move on to New York and Washington State. In New York in 2007, the state formed a multi-agency joint enforcement task force specifically on worker misclassification, similar to the one in Massachusetts. And this agency has been very actively addressing worker classification throughout the state. Its joint enforcement efforts came with a lot of successes initially. 12,300 instances of employee misclassification in its first 16 months, accounting for over $157 million in unreported wages. The Wage Theft Prevention Act in New York took effect on April 9th of last year, and similar to California, requires companies to notify employees of rates of pay, overtime rules, employer names, doing business as names, and has much stronger protections for whistleblowers, as well as the increased penalties for wage violations from 10 to 25,000. Again, just like California, these can be per worker per violation. And just like California, it comes with a scarlet letter provision that posting on a company's website or at their company headquarters that they have violated, in this case, New York labor law. The issue of misclassification was addressed broadly by a joint enforcement task force set up by Governor Eliot Spitzer in 2010. Later on, Governor David Patterson signed the Construction Industry Fair Play Act, which dealt with building trade abuses. And currently, the State Senate of New York is debating the Consumer Goods Transportation Fair Play Act, which would be targeting the trucking industry, and this was introduced just this past January. It's pretty clear that New York is sort of taking an industry-by-industry approach to misclassification. They've already done significant enforcement efforts and damage to the construction and transportation industries just by the beginning of these task forces, and it looks like there are a lot of other industries prone to abuses. A Drum Major Institute study that came out recently identified numerous industries ranging from professional services to healthcare. And as for which New York tends to target next, there's really no way to know, but they have followed a lot of these studies and research panels' guidance in the past. Now, for Washington State, there was a recent case, Dolan v. King County, where the Supreme Court of Washington very broadly extended the definition of employees. The case was shockingly one where public defender organizations, as you know, states are strapped for cash and public defender services are incredibly limited. But what they did was they partnered with legal defense services that were providing indigent criminals with defense provisions and representation. However, the Dolan v. King County decision determined that these legal defense services to indigent criminals were considered arms and agencies, that would be their exact words, of the county. This would be King County, and that as such, they were not independent contractors. It sort of relied on more common law principles, which is common in state and federal legal cases, and has significant implications across all of Washington for other worker relationships. In September 1st of this year, we saw Seattle joining San Francisco, Washington, D.C., the state of Connecticut, and potentially the city of Denver in mandating that employers provide paid time off for certain benefits. The ordinance requires private employers with 5 or more workers to provide sick time off and safe time. For many people who are unaware, safe time involves an employee's absence due to a business closure caused by a public hazard, a school closure caused by a public hazard that infects an employee's child, domestic violence affecting either the employee, a member of the employee's family or household, or a person with whom the employee has a current or former dating relationship. This is, again, a significant increase and extension of what is typically considered paid time off or sick time. As I mentioned before, the state of Texas is one of the more fledgling states when it comes to misclassification initiatives. They're following the lead when it comes to these other companies. I'm sorry, to the other states who are targeting various companies in their borders. They've determined that Texas employers who break the law and undercut more responsible businesses save an estimated 9% on their payroll taxes. And as we'll discuss later, simply taking a single independent contractor over a full full-fledged, full-time employee can save an employer approximately 20 to 30%. In Texas, despite local, state, and legislative efforts, though, it has been slower to adopt the same protections we've seen in the preceding states. One of these examples is a recent legal decision in Texas, the port elevator case, which was just in January of this past year. The court held that an employer who failed to pay premiums for temporary workers and failed to list the temporary workers' job classifications in their workers' comp policy could actually have a court award millions of dollars in damages against them and yet receive all of the legal protections of the workers' comp exclusive remedy for any of these workers who were injured on the job. Now, to be fair, these kinds of decisions are being attacked by public interest groups in Texas as endangering workers and flouting the law, but as such, it is still the law, and as you can see, Texas does not have nearly the same protections as, say, California or Massachusetts. In many states, but not all states, we're going to tackle sort of injuries on the job. Independent contractors are precluded from securing workers' compensation insurance. Ideally, they should be incorporated so as to properly obtain the insurance for their incorporated organization, but many do not and simply cannot afford to pay for this. This issue often arises when an independent contractor is injured on the job. Previously, they're more than content with their IC 1099 status, but once injured, they seek to have an employer-employee relationship with the company and obtain workers' compensation coverage and protection under the company's workers' comp policy. In Texas, there was a case where a plumber who was properly classified as an independent contractor under state law was asked by a building company manager to drive him across town for a supply run that was completely unrelated to the project the plumber was assigned to work on and contracted to work on. In transit, there was a very serious car accident. The plumber filed a claim for workers' compensation and was initially denied. He appealed, and an administrative judge ruled that because the plumber was not engaged as an independent contractor, was not engaged as an independent contractor and was engaged as an employee at the time of his injury, the plumber was considered to be an employee for workers' compensation purposes and was covered thereunder. Now, fortunately, in this case, the general contracting company had a workers' comp policy. However, if it didn't, the general contractor would have been subject to a penalty with the state for failure to carry proper coverage and would have been personally liable to reimburse the workers' compensation fund. Further, if the general contractor had not been subject to the Workers' Compensation Act at the time of injury and was not required to carry workers' compensation coverage, the company could have been sued in a civil action for damages by this injured plumber. Now, unlike states where wage theft acts have gone into effect in recent months, Texas, again, is still in the early stages that were experienced by California, New York, and Illinois only 3 to 5 years ago. There is currently on the ground in Houston the Houston Wage Theft Campaign, which is a signal of the same kind of community support that we saw in California and New York, and that brought this issue sort of front and center in front of the state legislature and in front of voters, and led to significant and sort of unprecedented increases in worker and wage protections, particularly in the area of worker misclassification. If such efforts, such as the Houston Wage Theft Campaign, will be successful in Texas, we have to wait and see. But the legislature in Texas is more than aware of the costs, if not to the workers, but to their own coffers. The state legislature recently issued a report that nearly $35 million is lost to the state of Texas unemployment insurance fund each year by misclassified workers in the state. Yet, despite efforts being slow to start, the federal government has not forgotten about this issue in Texas. The recent case of C&K Rental, C&K Supply Company, they recently settled with the Department of Labor for $433,000 in back wages to just 124 employees after a U.S. Department of Labor investigation found the company had misclassified FLSA-covered employees as independent contractors and denied them minimum wage and overtime compensation guarantees that are guaranteed under the federal law. The investigators in that case traveled to rural areas, they interviewed employees, they showed up unannounced on work sites, they discovered that their rates fell below the minimum wage, they felt that a lot of them were not paid 1.5 times for overtime rates, for those over 40 hours in a week, and that the company failed to maintain really any semblance of accurate records for employee wages, work hours, and employment conditions. So even in Texas, while the state may be slow to start, the federal government with the Department of Labor has not been. We'll move on to the courts across the nation. As many of you are aware, especially if you're in the HR arena, just about a week ago, the Brinker decision finally came down in California courts. Apart from clarifying the often strict and specific hourly requirements, including sort of how and when meal breaks and meal periods should be provided, it went into significant detail as well about the requirements and the burdens for a class action. The Supreme Court of California clarified that when a trial court's approach must be to determine whether to certify meal period and rest break claims, the trial court must resolve threshold legal and factual issues that are necessary to a determination of whether class certification is proper. Many consider this to have actually lowered the bar somewhat for class certification, and as anyone involved in a class action lawsuit knows, once a law firm, once a class of plaintiffs has secured class certification, there is a monumental increase in the exposure to the client, the resulting settlement amounts, and in the amount of discovery and attorney fees associated with it. If anyone has any questions about the Brinker decision later, I can be more than happy to go into more detail on that, but for now we'll focus more on misclassified workers specifically. Two of the biggest cases recently have been against corporate giants AT&T and Apple. Both AT&T and Apple appear to be drinking from the same trough when it came to classifying their workers. Both perceived that simply having all of their off-site call center, virtual call center employees classified as limited liability companies alone would somehow shield them from liability. These cases, which have survived motions for summary judgment, have proven that that was not the case. In short, as we well know, anyone who deals with this knows there is not just one rule that governs whether someone is an independent contractor or an employee. And in these rules, there are multiple factors, multiple things that need to be taken into account, and no single factor is ever held to be determinative. Even in the IRS case of having a 20-factor test, just having 11 out of 20 is not guaranteeing that you're going to be compliant with proper employee classification laws. Both AT&T and Apple are learning this the hard way. If AT&T, for example, in their case, is found to have the authority to exercise complete control, this is again the common law control test over the manner in which the work is performed by these at-home call center employees, they could be held liable for tens of millions of dollars in fines, fees, back taxes, and government penalties. Apple, however, went a step further, and it appears to, allegedly, according to the plaintiffs, to have forced its at-home call center workers to incorporate as virtual services corporations, sort of acting as a shell to shield Apple from liability and prevent them from paying any business expenses associated with that relationship. It then apparently forced them to sign these yellow dog contracts as sort of a condition of being hired. So there's a possibility here that Apple may be even even more hot water than AT&T is. But again, both of these very large class actions are ongoing in the court and have survived challenges by the companies and their defense counsel to get them resolved. Comcast Cable in Jackson, Mississippi, an unpaid overtime class action lawsuit has recently been filed just this year against principally an independent contractor of Comcast Cable Services. The allegations include that the technicians were not paid overtime and they were cheated out of reimbursement for business expenses. Again, similar pattern to AT&T and Apple. Now, we're going to quickly dive into exempt versus non-exempt employees. Now, again, this is an aspect of an employee. However, in many states, the distinction between exempt and non-exempt employees impacts a variety of applicable wage and hour laws. But employers should be very, very careful to evaluate employees as properly classified because they need to ensure that the applicable wage and hour laws are being satisfied with regard to all employees in the company. And the same is true of independent contractor classification. Employers should conduct the same analysis and classification of a new hire as an independent contractor or an employee, and then determine the exempt status of any employees, particularly because employers would be liable for, say, labor, meal and rest period violations related to misclassified independent contractors, because in the eyes of the law, as mentioned before, these misclassified independent contractors should have been treated as employees. We're going to go into Arnold v. Mutual of Omaha. This is a January case, California Appellate Court decision. It stated that insurance agents, for one example, are not employees under California Labor Code. This is a big win for the insurance agency. It reemphasized that though plaintiffs tried to sue for late payment of wages and unreimbursed business expenses, as well as unpaid federal and state taxes, it focused on the common law test. And again, this is why human resource departments, legal departments, and even procurement departments need to be very, very careful. Because the Mutual of Omaha case showed that no one factor, rather a totality of the circumstances, governs the relationship. If you read into depth in the Arnold v. Mutual of Omaha decision, you can see how closely the courts looked at these details. They looked at whether managers assisted insurance agencies or supervised them. They looked at whether they offered training or made that training mandatory. And they looked at whether software which was offered to insurance agents was merely a best practice or a mandatory company rule that they used that. Basically, in short, Mutual of Omaha is a great example of that reveals sort of the detail and the amount of scrutiny ongoing in the cases, and really it should be put AT&T and Apple on notice for the kind of strict scrutiny they are going to face in Perry v. AT&T and Hilton v. Apple, the two ongoing cases. Now we're going to cover some sort of broader federal regulatory trends. The DOL recently issued their 5-year plan governing 2011 through 2016. The primary focus, very clearly and very laudably, to create good jobs for everyone, and it did so by outlining 5 specific goals. But front and center in this plan is combating worker misclassification in no uncertain terms. It also singles out specific industries, just as was done with New York, specifically targeting certain industries, and California and Massachusetts and Connecticut. These range from, again, personal services and professional services, transportation, and healthcare. And specifically, the DOL said in no uncertain terms that it plans to utilize litigation strategies and penalty assessments to eradicate improper employee classifications. Another very fun and ever-changing area of regulations across the United States is the requirements for E-Verify. These vary constantly by states. In California, recently AB 1236 said that state agencies, cities, counties cannot require private employers to use E-Verify. However, in Alabama, a federal judge upheld in 2011 a law making the E-Verify mandatory by Alabama employers. Arizona, similar to Alabama, required all employers to use this otherwise voluntary federal program, and this law was upheld in May of 2011 by the U.S. Supreme Court. In Georgia, it's a little more attenuated. You're looking at private employers with more than 10 employees who need to check their employment status with E-Verify. But this, again, will be phased in over the next 2 years, beginning with employers of 500 or more, then employers of 100 or more, finally ending on July 1st of next year with those with 11 to 99, and July 1st of this year with employers with any more than 11, and July 1st of next year being anyone in that range. North Carolina, cities, counties, and businesses employing more than 25 workers are required to use E-Verify. And again, like Georgia, it's phased in over a 2-year period. But, you know, that may all be a moot point because Congress recently proposed the Legal Workforce Act of 2011, which would, amongst other things, make E-Verify procedures mandatory for all employers across the U.S. regardless of their size. COBRA audit guidelines have recently been revamped by the state and by federal agencies. employer contests COBRA eligibility, the required documents, auditor questions. It governs all of these things. Penalties can amount to $110 per day for mere notice violations, and an excise tax of $100 per day for if the violation continues. This can be potentially very extensive, and it has been capped at $500,000 for employers and $2 million for third-party administrators. With regards to 401k plans, the recent case of Tussey v. ABB, there was a 4-week bench trial that decided the fiduciaries of 2 401k plans were liable for $35 million in damages. They didn't exercise the necessary prudence with regard to the establishment and monitoring of administrative fees. This is one of the reasons why ICON, for example, as an employer of record, pays all administrative fees, try to get ahead of these sort of things. But these cases have shown that needs to be done on a much broader basis. The Department of Labor's new fee disclosure regulations, following state and sort of the State of the Union address earlier this year, the Department of Labor announced that 2 executive actions designed to enhance security for millions of Americans who are saving for retirement. First, service providers by July 1st of this year must provide employer-sponsoring ERISA-covered pensions and 401k plans with all information about administrative and investment costs. Now, I would expect, as an attorney, you should expect a new wave of litigation following these disclosures where the participants in these plans are suddenly becoming aware on July 1st, 2012, of alleged fiduciary breaches similar to the Tussey v. ABB case. Finally, in the Senate and the House, we had October of last year, Lynn Woolsey, she's a Democrat here in California. She reintroduced legislation that would create stringent new record-keeping rules for any employers that hire independent contractors. It would also impose massive new penalties for misclassification. Civil penalties would increase to $5,000. It would allow the IRS and Department of Labor to share a lot of data, again, as they're doing with these memorandum of understanding and information sharing agreements. The Senate proposed a similar bill last April entitled the Payroll Fraud Prevention Act. It held a subcommittee hearing on that in July, and just a few weeks ago, there was a newly proposed Rebuild America Act, which on its face focused on raising the federal minimum wage, but in the small print, you'll notice that it proposes significant reforms to overtime and worker misclassification laws, relying on very similar language to the House and Senate bills proposed in 2011. Now, the enforcement statistics are incredibly clear. I'm not going to go into too much detail on these because they honestly speak for themselves. As mentioned before, 1 in 4 companies fail a compliance audit. And almost half, about 46% of independent contractors are misclassified. Now, when a worker requests an audit, and that can be through an IRS SS8 form or just an informal inquiry, 95% of the workers who request a review, an official review of their classification, are reclassified, which means that in many cases, your independent contractors, or in this case, misclassified independent contractors, know better than you do that they are being misclassified. And when you're looking at what can result from this, penalties, fines, interest, all of these amounts can amount to about 70% of the cost that you paid for the independent contractor. So let's say you had an independent contractor work for you for 1 year, $100,000, and it turns out they were improperly classified, should have been an employee. It can amount to $70,000 for that one contractor. And again, the reasons for a lot of these is because audits can look back 3 years, which multiplies the amount of damages, fines, penalties that are open to federal and state agencies. States have been incredibly successful with these. There's been a lot of notable success stories. Ohio, they found that in their audit investigations, 47% of those workers were reclassified. Illinois saw a 21% in misclassification violators over the last 5 years. The California Employment Development Department netted about $112 million in payroll tax assessments between 2005 and 2007, $18 million in labor violations, and over $40 million in tax fraud cases. As mentioned before, the New York Joint Enforcement Task Force alone had over 25 million since September of 2007. And in Washington State, which has really gone above and beyond, the Washington State Labor and Industry Fraud Prevention and Compliance Workforce and Task Force makes $7 for every $1 they invest in worker misclassification enforcement. Now, what you're probably wondering is, how can we avoid this, and what could possibly trigger a lot of these audits, investigations, and lawsuits? One, filing of worker compensation claims by people who were classified and paid as independent contractors. Same thing with unemployment insurance filings. When you have an overlapping W-2 and 1099, often in the same tax year for the same individual, one who was paid at one point as an employee, paid at another point as an independent contractor, raises huge red flags, automatic red flags. Again, as mentioned before, we've got these information sharing agreements between agencies, a lot of overlap. Perhaps it may not violate one, it'll violate another, and they're sharing this information, specifically singling out and targeting the violating companies. Another issue, unmatched 1099s that don't match up with an individual who's working there. As I mentioned before, these formal requests that have a 95% hit rate with perceived independent contractors. This is a formal SS8 request. And the IRS whistleblower program, which can reward whistleblowers up to $10 million for calling out their an employer or a previous contracting agency. Finally, there's the secret auditors we mentioned before, created by Form 8919. So the company you're working for, it may be paying you as an independent contractor, but treating you like a regular employee. If so, the IRS issued a very convenient form for misclassified workers. It's used to help that worker figure out the reporting share of uncollected Social Security and medical taxes. And if you file the form, you pay less than you would, but the employer is targeted specifically and they will pay more. The Obama administration that we've mentioned over the course of this discussion has made no illusions about where it is focusing its money. We've seen a tenfold increase in the last few years in the amount of money dedicated to this. We've seen multiple states joining in with these enforcement initiatives. We've seen worker classification information sharing agreements between a majority of states just growing. This has all begun in the last few years and it's on a steady pace. The IRS hiring more enforcement personnel. Beginning 2,000 random audits per year, beginning last year and going on for the next 2 years. And as mentioned before, just in the last few months, we've added the 13 states to the official misclassification initiative, that being Louisiana in February of this year. So if you're wondering why, again, if it hasn't been completely obvious at this point, when in doubt, you're looking at who's going to make money off this. As we've mentioned before, companies make a lot of money off having independent contractors, assuming they are properly classified. That's a 20 to 30% savings. It could be 15% over someone who's just paid on an hourly rate. And again, this is because they eliminate workers' compensation costs, unemployment insurance costs, costs of health care benefits, FICA, employee stock purchase plans, 401k matching, bonuses, merit increases, space costs, office space, parking, equipment costs. And again, with this certain economic situation we're having right now, ups and downs and fluctuations with demand, rather than cementing the full fixed costs of a full-time employee, naturally companies are preferring independent contractors, which they can increase, decrease, on-board, off-board, project-specific basis as needed, rather than cement those very high full-time fixed costs. And again, as we've mentioned before, you've heard many different states, many different standards. Again, generally in IC, they'll commonly work for one business, provide their own resources. There's a low level or no level of control exercised by the hiring business, and the focus is on the completed work, not the manner in which it's done. The IRS, again, has their 20-part common law control test. No one thing is determinative, as AT&T and Apple have learned, and even 11 out of 20 is not going to guarantee you. The Department of Labor's Unemployment Division, they have their 7-point Economic Reality or ABC test. And the National Relations Board, they fall somewhere in between the two. the Tax Equity and Fiscal Responsibility Act of 1982 put up a lot of roadblocks to even the IRS actually clarifying what an independent contractor is. So it doesn't look like there's going to be any resolution and specific outlined rules when it comes to this anytime soon. So we'll just finish up here. Best practices, the keys to compliance. It's very complicated. You want to navigate this maze of laws and regulations of legal standards as quickly and efficiently as possible. First, you want to address the relationship with the company and the contractor. You want to review the vetting process. You want to make sure it's flexible and adaptable as the law changes and all these federal and state rules and regulations come into effect. Secondly, companies want to focus on the status of the contractor through a concise and easy-to-use validation process, which answers the key questions such as, is the worker set up as and operating as independent business? Does the worker have the required insurances? And do they have all supporting documentation? Finally, you want to maintain security. The key point of having this is also for your company's confidential information and clarifying who owns intellectual property in a lot of these engagement opportunities. Through onboarding and offboarding processes that use clear contract language, you can make sure you maintain and secure all of this information. Again, companies can choose to implement this process internally, dedicating a segment of HR or legal to oversee the process, or they can partner with compliance companies such as ICON, which are kind of our sole responsibility is to manage the system I just described. The one thing we do is we remain up to date, as you can see from this presentation, with the multitude of newly enacted laws and regulations throughout all the states and in the federal government. But honestly, whether your company does this internally or externally, they want to streamline the process. They want to decrease the onboarding time. That includes all of these vetting and validation processes contained within it. And you want to allow your company to retain and use key and proven contract talent and gain visibility and reporting into all of your labor spend, including independent contractors, not allowing them to go through the system, as we mentioned before, as sort of these nameless, faceless purchase orders. Again, you're going to also want to align human resources, procurement, and legal, get them on the same page. They often have very conflicting motives. HR, looking for compliance as well as quality. Procurement, concerned with spend. And legal sort of caught in between limited resources and tackling red flags and ongoing lawsuits and audits. So again, these are sort of your best practices. When focusing at this, you have to take account of all of the varieties of different laws and regulations, and you really want to get it into one concise package so you can stay ahead of the states, ahead of the federal government, and ahead of plaintiff lawyers like I used to be, and make sure that you avoid all these audits, fines, penalties, and forced reclassifications. So now if there's any questions, I'd be more than happy to take them. Also available to take them via email, but if you feel free. I think we've addressed most of our best practices as well as a lot of our frequently asked questions. Thank you all for your patience and coordination. Oh, we have one here, a question about the current case, and that was the Brinker decision. Again, that's going to cover all of your employees and how much they're paid. Just to give you a quick breakdown of where that falls. Work hours in a shift, according to Brinker, must be divided by 4 and rounded to the nearest whole number. Employers are then entitled to a number of rest periods, except if their shift is 3.5 hours or less. So for under 3.5 hours, no rest period. 3.5 to 6 hours, 1 rest period. 6 to 10 hour shifts, 2 rest periods. 10 to 14 hours, 3. And if the employee has the option to skip one, and that is their choice, and they are provided with that option and not prevented from or dissuaded from doing so, it is completely in line with Brinker. As for when that break should be, based on the reading of the court's decision, probably more likely to be in the middle of those blocks of times whenever feasible. As for meal periods under Brinker, if the employee has at least 30 minutes uninterrupted and is free to leave the premises and is relieved of all duty for the entire period, it is in compliance. Again, employers cannot coerce or pressure employees to skip their meal breaks. And as for timing, the court outlined that it provided no more than 5 hours of work and a second after no more than 10 hours of work. It does not, however, specify whether that needs to be at 5 hours, so from 5 to 5.5, or before 5 hours. So to err on the side of caution, general advice is then to go before 5 hours, so at 4.5 hours. If there are any more questions about any of the incorporated contractor cases, we're more than welcome to take those. But at this time, we've hit our 1 hour mark. I'd like to thank all of you for participating, and thank you again.